Okay, today we are going to discuss about termination of obligation. Yeah. So if you look into the KUA Perdata, the ICC, you will see that there is a section chapter 4 1381, ya, perikatan-perikatan hapus, and then the reasons. Yeah. So Article 1381 stipulates 10 ways to terminate obligations. Yeah. The first one is by payment. By payment dengan pembayaran, ya. By cash payment offer, penawaran pembayaran tunai. This is what we understood as konsinyasi, consignment. By renewal of the debt, pembaharuan utang, ya. We will discuss this that because this is called also as novation, novation of agreement. By set-off or compensation, ya. This is perjumpaan utang, ya. So don't get confused with the English terminology, but you must also understand the Indonesian phrase, ya. Perjumpaan utang. So set off, in English it is set off. I can set off your debt to me against my receivable, for example, yeah. Or we can call it compensate. We compensate our debts, yeah. Compensation, set off, yeah. So in English, these two phrases can be used, but in Indonesia it is called as perjumpaan utang, yeah. That's the legal terminology. By mixing of debts, I don't know whether this is the correct phrase for this, but the point is this is the percampuran utang, ya. So there will be a mix in one person of debt and receivable, ya, percampuran utang. By relief or release, ya, from a debt, pembebasan utang, ya. So you are released from your debt. By the destruction of the object that were owed. Yeah. So the object is destructed, it's gone. Yeah. We discussed related to this provision last week about the risk, right? That risk may also involve the destruction of the property or of the goods that is going to be delivered. By null, nullification, this is batal atau pembatalan, ya. And then by the implementation of a void condition or void requirement, ya, syarat batal, ya, berlakunya syarat batal. And then by lapse of time, this is what we normally call a statute of limitation. So there is a daluarsa, ya, expiry period. There is a daluarsa time, there is a period when you can claim something or you can lose something. Yeah, you can have your right to claim, or even in contrast, yeah, you can lose your right to claim. So we are going to discuss this one by one. Yeah? That's why I told you in the beginning that this session will be quite tough and lengthy. And it's not easy for me also, some subjects, yeah. So that's why I will try to explain, and hopefully we can get it done. All right, by payment. Now, by payment is considered like quite wide interpretation, yeah, because payment is not only involving money, but also involving delivery of goods, yeah. So the meaning of by payment is any voluntary fulfillment of the agreement, yeah. So it's not only about the paying of money, yeah. If we refer to the word payment, we normally understand that this is the payment of money, right? What else we should pay if it is not related to money? But legally speaking, and under the interpretation of ICC, it is not only that, yeah. It is that, yeah, it is payment of money, but it is not only that. It is also related to the delivery of goods, and also any performance that is fulfilled under the agreement. Yeah, there is also fall under the category of payment. So that's the second point. In a broad meaning, by payment is not only interpreted as the buyer paying the purchase price, but the seller is also said to pay if the seller hands over the goods that he is selling. So it's like performance, actually, payment. So we are talking about termination of obligation, right? So the obligation is terminated because you pay. Now, when you are regarded to have paid, means either means in principle that you have performed your obligation, right? So what is your obligation? It may involve payment of money, right? Or it may involve just a performance or a delivery of goods or doing something or not doing something. That is your payment. In addition to debtors, the party that is obliged to pay a debt is also a debtor's friend and a debt guarantor. Yeah, the party that is obliged to pay a debt is also a debtor's friend and a debt guarantor. Yeah, this is the obligation, because if you have debt, yeah, I call debt itu utang ya, debt ya. So if you have debt and you have a guarantor to secure or to guarantee that your debt will be paid, then of course your obligation to repay your loan will also cover the obligation by your guarantor, right? Your borg or penanggung utang. ICC stipulates obligation may also be fulfilled by a third party who has no interest, as long as this third party acts on behalf of and pays off the debt of debtor. So acting on behalf of means acting as proxy, as power of attorney, as kuasa, yeah. Or if he acts on his own behalf, he does not replace the debtor's right. So anyone can pay as long as you act on behalf of the debtor, yeah. Or if you don't act on the debtor's behalf but on your own behalf, you cannot replace debtor's right, yeah, because it is weird if someone or somebody just repays our debt and then suddenly replaces all our rights as debtors because we don't approve it anyway, right? We don't know it. But if we know, we approve it, and this third party acted on our behalf, of course, that will be another story. So the payment is valid if the payment is made in good faith. Okay. I don't think there is explanation on this. But yes, of course, the payment, if it is related to the performance under the agreement, yeah, we understand from the 1338 paragraph 3 that the agreement must be performed in good faith, right? 1338 ayat 3. So I think that's the principle. Suatu perjanjian harus dilaksanakan dengan itikat baik. So that is the implementation of the agreement. Yeah, the obligation, if you want to fulfill or perform your obligation, then it will apply the same. Yeah, it has to be done in good faith. So the payment is valid if the payment is made in good faith. Well, the debate will be, how can it be, how or when the payment is not done in good faith? If the payment is made by an incompetent person, then the payment is not valid. Yeah. So what we are talking now, actually, you can refer to the ICC, yeah. Or if you don't refer now, at least you will refer it someday, yeah. So 1381, right? That's the beginning. But then 1382 tentang pembayaran, ya. Bagian ke-1 tentang pembayaran. So starting from 1382 and then goes until 1403. Yeah, because the discussion will also discuss about the subrogasi. Yeah, that is only under the category of payment. Yeah, so payment involves many different things. So you can see it, yeah, if we refer to the 1384, for example, it is necessary that the payer is the full owner of the delivered goods and is authorized to deliver it so that the payment is valid. Ya, adalah perlu bahwa orang yang membayar itu pemilik mutlak barang yang dibayarkan dan juga berkuasa memindah tangankannya. So he must be an owner and he must be authorized to deliver it, right? So if we talk about whether he is authorized or not, of course we have to check whether there has to be consent or approval by the other party before the owner can transfer it. Yeah, for example, the company has assets, right? The limited liability company has assets. But when this company intends to sell this asset out, perhaps there has to be approval by the commissioners, for example, board of commissioners, or even in some cases, there has to be approval by the general meeting of shareholders. Yeah. So I think this is what it relates to, ya, agar pembayaran yang dilakukan itu sah. The debtor must not force the creditor to accept the payment of his debt partially, although the debt can be divided. Yeah. If the debt, if there is no agreement that the debt is to be divided, even though it is can, yeah, you cannot force the creditor. Well, I think this is an essential part under the agreement, right? If we have agreed something, it will be binding between us. Of course, you cannot force me to agree otherwise, yeah, unless I agree to it, yeah, unless I agree to it, yeah. But as long as I disagree, you cannot force me, of course, even though it is possible by nature, right? Because we are talking here that it is possible by nature that I can divide it. But if I never agree to it, so you cannot force me to do it. So the payment, to do it or to pay, where should I send the payment, or where should I send the money? So in here, you can look to 1393. Pembayaran harus dilakukan di tempat yang ditetapkan dalam perjanjian. Ya. Jika dalam perjanjian tidak ditetapkan suatu tempat, maka pembayaran yang mengenai suatu barang yang sudah ditentukan harus terjadi di tempat di mana barang itu berada sewaktu perjanjiannya dibuat. Di luar kedua hal tersebut, pembayaran harus dilakukan di tempat tinggal si berpiutang, creditors, ya. Selama orang ini terus-menerus berdiam dalam keresidenan di mana ia berdiam sewaktu perjanjian dibuat, dan di dalam hal-hal lainnya di tempat tinggal si berutang. Nah, terbalik sekarang. So, in a place where the agreement is made. So, the place of the agreement, or if there is no place, then you refer to the place where the goods are, yeah, when the agreement is made. Of course, this is just a provision, yeah, basic provision. If you forget to stipulate in your agreement, you can do this, right? But in practice, of course, we will always pay in a place where we agree, right? If we go to the supermarket, for example, that is the place where we pay the money, right? So we have an agreement to sell and purchase of things in the supermarket. and then we immediately pay. So there is no argument. Now, outside the supermarket, sell and purchase. Now, of course, we normally just send our payment through a bank transfer, right? Well, sometimes with cash, and even though it is with cash, it has to be, it is always be with a receipt, yeah. So now again, even though we don't agree in writing, doing this kind of transactions, of course we communicate, ya. Hey, gue bayarnya gimana nih? Ya kan, gue bayarnya harus bagaimana? And then the seller will reply, you can do this and this, right? So we agree. And now, of course, with the emergence of apps and everything is regulated. If we use some sort of mobile apps, we have to pay various means, right? We can use credit card, we can use virtual account and everything, and it will be deposited to the escrow account. So that is the agreement, right? The seller and the buyer, the seller of the goods and the buyer agrees that this is the mechanism of payment. So that is the agreement. Well, we can see here that this is very outdated, yeah, but at least this can still be a principle when we want to understand actually where we should pay the money, right? And I think the other interesting subject in here is the 1395 actually, yeah, it's not here. The 1395, biaya yang harus dikeluarkan untuk menyelenggarakan pembayaran dipikul oleh si berutang. So sometimes there are questions, yeah. There are questions biaya yang harus dikeluarkan untuk menyelenggarakan pembayaran. If I'm not mistaken, in the sell and purchase section in the ICC, there is also a regulation that the biaya untuk melakukan pembelian, ya, dipikul oleh pembeli, gitu. So it's a similar provision, ya. But 1395 deals in general, of course, ya, because it's just using the yang berutang, ya. When in sell and purchase section, it refers to the buyer. So there are some questions sometimes, yeah, when we receive money, maybe from outside the country, and between banks, there will be administrative fees, right? Banks will deduct some fees because you transfer the money outside the country, for example, maybe from Indonesia to America or United States to Indonesia. And then there will be administrative fees, perhaps 100,000, 200,000, 300,000. And who should bear that payment, right? So legally speaking, under our ICC, it should be borne by the buyer or the payer, yeah, who is indebted or who is obliged to pay. So it is clear now, because sometimes the transferor does not understand, right? And of course, because of that, we as the receiving party will have to bear that cost, yeah, even though we do not obliged to bear it. And then the other next point is about subrogation. Yeah, we are going to discuss it after this. In subrogation, a third party who pays a debt replaces the position of creditor against the debtor. So after the debt is paid, a new creditor appears who replaces the old creditor. The debt was removed because of the payment earlier, because of the earlier payment. But at the second, maksudnya tuh dalam detik yang sama atau detik berikutnya gitu ya, live again, I mean resume again, ya. Resume again with the third person as a replacement from the old creditor. Okay, let's try to see this. So subrogation can occur based on agreement and based on law. So if you want to understand and see further these provisions, you should look 1401 and 1402 and 1403. Yeah, so it's only and 1400 ya. Subrogasi atau penggantian hak 1400. Subrogasi atau penggantian hak-hak si berpiutang oleh seorang pihak ketiga yang membayar kepada si berpiutang itu terjadi baik dengan persetujuan maupun demi undang-undang. But the detailed explanation of this is only actually 3 provisions, 1401, 1402, and 1403. So it can occur based on agreement between the parties, yeah, or it can occur based on law, yeah. So there is no need an agreement, but it will happen anyway if it happens, gitu. It will be considered as legally subrogated or legally transferred, even though there is no agreement. Now, by agreement, there is a category. I mean, there is a perspective from the creditor and from the debtor. As you can see from the first point, I italicize the creditor word, and then the second point is the debtor word. So by agreement, if the creditor accepts payment from a third party, yeah. So you imagine you are a creditor, accept payment from the third party, determining that this person will replace his rights, meaning creditor's right, yeah, his claims, privileges, and mortgages that he has against the debtor. This subrogation must be expressly stated and made at the time of payment. Jadi kreditur, saya menerima uang dari pihak ketiga. Lalu saya tegaskan bahwa hak-hak saya di dalam kredit ini berpindah ke Anda, pihak ketiga. Ya, dan ini harus tegas. This subrogation must be expressly stated and made at the time of payment. Jadi dia bayar saya, ya. Pihak ketiga ini bayar saya. Kan kita bicara konteksnya pembayaran, ya. We are still in the context of by payment. And then the second category, now from the debtor. Yeah, the first one is from the creditor. The second one is from the debtor. If the debtor borrows some money to pay off his debt, yeah, and assume that the person who lends the money will replace the rights of the creditor, then the subrogation is valid. Both the loan agreement and the letter of repayment must be made with an authentic deed. And in the letter of loan agreement must be explained that the money is borrowed to pay off the debt, while then the letter of repayment must explain that the payment is made with the money for which it is lent. Okay, meaning in a subrogation, the creditor can replace another creditor. Yeah? A new creditor can replace an old creditor and take over all the creditor's right. Yeah, and in the similar way but different subject, whether in this matter it is the debtor can find another creditor. Yeah, so the first category, creditor finds another creditor, right? Creditor finds another creditor. The second category, debtor finds a new creditor, right? Where this new creditor, he will sign it in an authentic deed, right? He borrows money that he says this money will be used for payment to my existing creditor, right? So this new creditor will then replace the position of the old or existing creditor, right? So this is the subrogation by agreement. Perhaps this is you can see that this is a takeover loan, yeah, sometimes by the debtor, yeah, takeover. So the KPR di take over lah, KPR take over atau loan take over lah. This is something like that, yeah. So the debtor finds the new creditor to pay off the existing creditor. So that's subrogation, yeah, because I paid my money to you using the new creditor, and it's done. My obligation to you is terminated. Yeah, remember that we are talking on the termination of obligation. So creditor replaces creditor can also happen actually dealing in many property projects, for example, where the property is constructed and the certificate is not subdivided yet. So the bank can provide financing to the customers, but the bank cannot hold any mortgage because the certificate is not issued and subdivided yet, right? So the bank will make the developer to promise if the customer breaches their obligations to repay the loan, then the bank will transfer like this, will subrogate all the debts by the customers to the developers. So this is the change of creditors, yeah. So the existing creditor, the bank, will transfer their receivable against the customer who is not paying anymore, transfer to the developer, the new creditor, right? And this developer as new creditor will then will then collect the money from the customers. So the bank is paid off, right? The bank is paid off. They walk away happily, and then the developer is suffering, yeah, because they have to now chase the customer who may not pay anymore, and it happens sometimes. The customer just doesn't care. And then by law, this is happening by law without an agreement. For a creditor who repays to another creditor based on special right or hypothec is ranked higher than the other creditor. So if he has a mortgage or he has, this creditor, I mean, preferred or preferential right, he is able to repay and then taking over the receivable. Yeah, that is subrogation also. For the buyer of any immovable good who uses the payment of the goods to repay the creditor against whom the good is secured. Well, sometimes we might find when we want to buy a property, but the property is mortgage, right? So we can only buy the property by also paying the debt to the bank, right? Because if not, then we cannot buy. Yeah, we cannot buy before this mortgage is lifted up from the property. So we have to pay the bank, and by paying the bank, we replace the position as creditor. So this actually, when we as the buyer becomes the creditor because we replace the position of the bank, then the buyer is also creditor because the seller is also a creditor, right? Because the seller is entitled to receive money, purchase price from me, right? But I am also the creditor because I'm now taking over the position of the bank. So that can be a compensation of debt, actually, the set-off that we are going to talk about next. For those who, together with others or for others, are obliged to settle a debt, or who have interest in the payment of such debt, has interest to settle. Yeah, this is some other stories. Perhaps there are agreement between them and they have to pay it, right? Because they are obliged to do it. So they pay it and then they replace it, legally speaking. For an heir receiving heir with special right to record the inheritance, has paid inheritance debt with his own money. So these four things are subrogation by law, yeah. But the two things before are subrogation by an agreement. Yeah? So there has to be an agreement, of course, and it has to be in writing, I think. Yeah, I don't think it can be inferable in this case, subrogation. Yeah, because you have to prove that there is a subrogation. But of course, in this by law, you don't need to prove anything that there is an agreement because it happens by law. As long as these 4 points are fulfilled, then you can say that you replace the position of the existing creditor. Okay, that is the first point only, and we already spent more than 30 minutes. Okay, so I immediately go to the second point. This is consignment, konsinyasi. Maybe you heard it or most, yeah, konsinyasi. Penawaran pembayaran tunai. So if you look, penawaran pembayaran tunai diikuti oleh penyimpanan atau penitipan, ya. Foreign 04 to foreign 12. The method is a way of payment that must be made if the creditor refuses to pay. Yeah. So if you are the creditor, you are entitled to receive the money, right? Not refuses to pay, refuses to be paid, right? So you are entitled to receive money, but you don't want to be paid. Well, we don't know, for whatever reasons, yeah. Maybe you are entitled to get money because you win the court case, right? But you are not happy with the court case, so you decline it. Well, legally speaking, as long as the debt is clear, the amount is clear, it is definitive, and I have to pay because I'm obliged and you are entitled, right? If you don't want to receive, if you don't want to accept the payment, then I will put it to the court. Yeah, that's the easy way to see it. I just put the money at the court. And when I put the money or I deposit the money at the court, legally speaking, my obligation to you is already terminated. Yeah. So actually, this can happen in many cases. Yeah. In settlement, for example, that the parties have agreed to settle between them that they are entitled to be paid in this amount, right? In the court case, and for example, if you look to the land procurement law 2012 and as amended by the job creation law in 2020, you can see that they also use the same concept, konsinyasi, but the difference, I think, they expand the conditions. Yeah, it's not that the creditor refuses to be paid only, but when the creditor is not clear, the whereabout of creditor is not clear. Arti keberadaan kreditur itu nggak jelas di mana. Yeah, the whereabout of creditor is not clear, or the land is still in dispute. Yeah, or the owner of the land declines, right? And some other things, I think. The other point, I think only 4 points. So if that is the case, yeah, the government just deposit the money and that's it. The obligation by the government is terminated. The obligation by the government to compensate for the land is terminated after the money is deposited on the court, at the court. Yeah. And the land is deemed to be relinquished to the state, right? So the state can immediately certificate the land and occupy the land and do the projects there. Okay, now the mechanism, right? How is it done then? This is the general way, right? What I was just talking about on the land procurement law is more specific way. That is under the land procurement law, but this one is under the general, any aspects, yeah. So this method is as follows: the goods or money to be paid is officially offered by a notary or a bailiff. Well, almost never seen a notary. Yeah, it is always a jurusita. Yeah, I don't know whether there is still a notary offering this. The notary or bailiff makes a detail of the goods or money to be paid and goes to the residence of the creditor by saying that the notary or bailiff is ordered by the debtor to pay the debtor's debt, right? See? Ordered by the debtor. Yeah. If the creditor receives the goods or money, then the case has been completed. But if the creditor refuses, then the notary or bailiff will allow the creditor to sign the verbal process. Ya. Jika dia tolak, harus ada buktinya juga. Then the debtor will authorize the payment offer and the goods or money to be paid, consigned, or deposited to the bailiff of the district court, and the debt is removed. Yeah, so the money is put and deposited at the district court, and then by doing that, the debt is considered to be removed. In addition, follow the cash payment offer, maksudnya ini ya, penawaran pembayaran tunai maksudnya. Mungkin frasenya kurang bagus ya. Penawaran pembayaran tunai. Because the konsinyasi is always related to penawaran pembayaran tunai. So we offer to pay money. Followed by consignment or deposit is valid and valuable. It shall be followed by an application. Now we are talking about the application at the court. When you apply to the court, you must demand, yeah, that it will contain that it is a valid and valuable, the cash payment offer, followed by consignment or deposit, imposes a sanction to the applicant to pay the court fees. The legal effect. The debtor may reject the claim for fulfillment of performance. Why? Because by consigning the money, by depositing the money, you are deemed, your obligation is deemed to be terminated. Yeah. The debtor no longer owes that interest since the day of consignment. Maksudnya nggak bisa lagi dikenakan bunga ya. Karena saya sudah bayar tuh. Utangnya saya sudah bayar. Jadi bunga sudah tidak lagi bisa dikenakan. Since the day of consignment, the creditor bears the risk now. Now the money is there at the district court, for example, right? Will you get the money or not? If you don't get the money, it will be your risk, right? Because the money is there at the court. It is your right to recover it because I have already given it at the court. Yeah, but if you don't give it, if you just ignore it, and then the money is gone, perhaps, or the money is distracted, yeah. I don't know whether it is possible happening in the court, yeah, but I think there is still a risk, right? If you delay not taking it. So I had experience when I dealt with a developer, and then there is a dispute with the customer. The customer is unable to continue the purchase price of the apartment. Let's say that the apartment is 2 billion. She bought it, and she paid only 600 million, for example, yeah. So 2 billion and then paid only 600 million. And then it is going to be terminated by the developer, yeah, because she has not paid the installment anymore. And then, of course, there was a negotiation, and then this buyer would like to be, the money would like to be repaid, everything plus interest, yeah, because she said that the 2 billion is not 2 billion anymore, perhaps 2.5 billion or 3 billion, yeah. So you can see sometimes, you know, people that are not doing their performance and then reprimanded to do their performance becomes more fearful than the party who is doing their promises, right? So this is the life that we are experiencing every day, yeah, facing with this kind of different people in our life. So and then what happens, there is a dispute, of course, because this buyer insisted to have been repaid with more than what she has paid, yeah. And then we went to the court and to just deposit the money, right? So we terminate first the agreement, and then we deposit the money, and then they will file they file a claim. Yeah, they file a claim to the court. The claim was declined because it has to be through arbitration. Yeah, it cannot be through court anymore because there is an arbitration clause. And then we put the money at the court as deposit. So penawaran pembayaran tunai, we follow this procedure. What happens next then? They were still disputing with us at first, and then they stopped. Yeah, they stopped and they took the money from the court. Yeah. So then it is considered that the agreement between this buyer and the developer is terminated, right? Because she voluntarily gets the money anyway. Yeah. But legally speaking, this developer's obligation to refund the money actually terminates when the deposit is made. Yeah. Not when she took the money. Okay, so that was the good case. Yeah. The second case that we have also involved in consignasi, but then it was challenged. Yeah, it was challenged. The consignasi, it was challenged, and until Supreme Court, and now it's a judicial review. It was not decided yet, but I think it's going to be interesting. Yeah. Okay, let me continue now. The third point is renewal of debt. This is what we call as novation. There are three ways to implement a renewal of the debt or novation. So the objective novation, the subjective novation, passive, and active. Yeah. So objective novation, if for the benefit of the creditor, the debtor enters into a new debt that substitutes and removes the original debt. The second point, if a new debtor substitute the original debtor. So the second point talks about the debtor, yeah. Substitute the original debtor, whom the creditor is released from his debt. So if new debtor substitute the original debtor, who is released by the creditor. The change of debtors. If pursuant to a new agreement, a new creditor replaces the original creditor in respect of the latter, the debtor is released from his obligations. Yeah. So the second point is the change of debtor. The third point is the change of creditor. Yeah. Subjective. Why is it subjective? Because it only changes the subject, the party. While the first point is the objective because it changes or it converts or it replaces the original agreement. Okay, just a quick through on this. The first point, the example you can read from the book of Hukum Perjanjian, but the example is like this. If you buy things, you have a sell and purchase agreement, right? But then you said to the seller, I cannot pay the money very fast, because I need some time. So can I change it to the loan agreement with interest, for example? So I change the sell and purchase agreement with a loan agreement plus interest. So that is the objective novation actually. Because you change the agreement, the object of the agreement you change. The sell and purchase, but then you change it to the loan relationship. So the sell and purchase is terminated when you sign a loan agreement relationship. So the loan replaces the sale and purchase agreement. The sale and purchase is terminated, but then the loan is emerged, right? The second point and the third point is just changing of the subject. So it's not the object. Now, what is the difference with the subrogation, right? The novation can be performed only by the person who is competent by the law, of course. This is also applicable to the subrogation. The novation cannot be presumed. The will of parties that intend to carry out the novation shall be clear from the deed. Okay, we saw before that the subrogation can be under the law, right? Not only by the agreement, but can be under the law. But the novation is not. The novation, it must be very clear from the beginning, and it has to be in writing, because it must be clear from the deed, right? And then the difference with the subrogation also, the novation terminates the previous relationship. because it's a renewal of the debt, ya. Itu pembaruan kan. Ini kan namanya pembaruan. So when in the subrogation we saw that all the privileges, mortgages, pledges, ya, jadi semua hak yang dipegang oleh kreditur existing, subrogasi itu berpindah ke kreditur baru. All the rights to claim and blah blah blah. Novation is not, unless it is declared in writing in the novation agreement. Yeah. And subrogation, we can see that by agreement, subrogation by agreement can be by the creditor and by the debtor, right? But this one, novation, it has to be a three-party agreement. Yeah? So it is a three-party relationship actually. The first, the existing creditor, the new creditor, and the debtor, or the existing debtor, the new debtor, and the creditor. So it must be agreed in writing, and it must involve the three-party relationship in order to proceed with the novation. It's different than subrogation. Yeah? Subrogation, you don't need to involve the third party. You can do it by yourself. When we refer to the creditor's subrogation or the debtor's subrogation. And the other point is novation must be in agreement, must be in writing. The subrogation can be by law. It doesn't have to be in it cannot only be limited based on agreement. And then the other thing is subrogation is just like, even though it is terminated, but it is just continuing because the rights of the existing creditors are still valid for the new creditors. Well, it is not the case for the novation, because for the novation, it is considered as renewal of the debt. So the old debt is terminated, the new debt is made. Well, the new debt does not really take over all the rights under the old debt unless it is specifically clear and agreed in writing. Yeah. Well, this is not easy. The difference between subrogation, novation, and I will add it again. Another thing is called cesi, right? I think we talk about it perhaps. Yeah. That's another issue. But it is good to understand the differentiations between these things, yeah, because it is important under our civil relationship. And then by set-off. Set-off or compensation is the removal of each debt or the termination of each debt by taking into account debt that has been collected between the creditor and the debtor. Each debt may be removed by set-off or compensation. Jadi perjumpaan utang ini intinya ya. But the amount of each debt shall be determined and also due and payable. Tentang kompensasi atau perjumpaan utang, you see to 1425. Wow, this is quite many ya. 1425, 1426 to 1435. Ya. Tentang perjumpaan utang. So if the amount of each debt already determined, but one of the debts is not yet due, then set-off cannot be carried out. Ya. So set-off kan perjumpaan utang. Yeah, so I have debt to you. Yeah, it means that you have receivable against me, right? But on the other hand, you also have debt to me. So I have receivable against you, right? So there is a debt relationship between us together. Yeah, let's say that I have to pay 100 to you. Yeah, so you are entitled 100. I have an obligation to pay 100. But on another hand, you also have to pay me 150, right? 150. So I am entitled to receive 150 from you, right? So that is the relationship. Now, 100 and 150. So when there is a compensation or when there is a set-off, it means that, let's say that this is A and B, right? A has to pay 100 to B, B has to pay 150 to A. When the debt is compensated, the deficit will be 50, right? Because 100 and 150, when it is compensated, the deficit will be 50. So that's why the B is obliged to pay the remaining 50. Yeah, because the 100 is already compensated, right? Because A must pay 100, right? But the other one, B, must pay 150. So the 100 can be set off, right? It's gone. But the 50 is still there. So the B's obligation to pay A is 50 then. So that is the compensation. But of course, in the third point, you see that the debt must be due and payable. Hutangnya harus jatuh tempo dulu. Nah, karena kalau tidak jatuh tempo, gimana bisa ditagih? Gimana bisa dibayar? It's similar to our discussion when berkaitan dengan ketetapan waktu ya. Obligations to pay within a certain period of time. Kalau kita wajib bayar tanggal 1 setiap bulan misalnya. 10 kali bayar. Ya, pembayaran kelima kan bulan kelima. Sekarang baru bulan kedua. Artinya kan kita belum wajib bayar bulan kelima. Artinya belum ada kewajiban untuk bayar kan. Belum jatuh tempo itu namanya. Nah, sama kalau dalam if that is the case in this regard, of course you cannot compensate. You cannot compensate the future obligations with this concept ya. The perjumpaan utang, the compensation, it must show that the debts are due and payable between A and B, B and A. Yeah. But when the debts are due and payable, then of course they can compensate. The arrangement regarding the set-off can be seen under the article 1424. Because of the renewal of debt between creditors and one of the debtors who owe joint and several liability, the other debtors are released from the obligation. Yeah. Debt novation in respect of the principal debtor releases the guarantors, of course. Yeah. If the principal debtor kan debitur utama ya, artinya the one who is owing the money. Of course, when it is paid, it will release the guarantors. However, in the first instance, the creditor demands the participation of the co-debtors, and if in the second instance, the participation of the guarantors. But the co-debtors or guarantors refuse to enter into the new agreement, then original debt obligations remain in effect. Well, this is related to the novation actually, yeah. Yeah, this is related to the novation. I'm not sure why is it here. Let us just disregard this. Now by mixing of debts, yeah. So by mixing of debts, 1436 and 1437, yeah. Only two provisions in here, yeah. It's so simple. Apabila kedudukan sebagai orang berpiutang dan orang berutang berkumpul pada satu orang, maka terjadilah demi hukum suatu percampuran utang dengan mana piutang dihapuskan. If a person is a creditor and debtor, then it happens by law a mixing of debt, with which the debts are removed. Example, the debtor is in a testament, maksudnya wasiatnya, is appointed as the sole heir by his creditor. Nah, jadi orang berutang pada orang lain. Kan jadi saya debitur, orang lain kreditur, toh. Tapi tiba-tiba oleh kreditur yang mengutangi saya itu, dia menunjuk saya sebagai ahli waris tunggal di wasiatnya dia, ya. Jadi kan otomatis saya yang berutang, ketika dia meninggal, piutangnya bercampur sama utang saya kan. Nah, that's piutangnya si orang yang memberikan wasiat ke saya kan artinya kan ketika dia memberikan wasiat artinya piutangnya kan beralih ke saya. Sedangkan saya yang berutang kan. Jadi piutang yang tadi dari pihak ketiga ketika dia meninggal berdasarkan wasiat masuk ke saya, bercampur kan di dalam diri saya. So the similar event also can happen like when you perhaps you have debt with a woman, let's say that you are a male, then you have debts with a female, and then this female later on becomes your wife, for example, and there is no prenuptial agreement, for example, yeah. So there might be also a case where there is a percampuran kan utang piutang. The removal of receivable debt in the event of this mixing is for the sake of the law. Yeah? So it is automatic. Yeah, it is like null and void. It is automatic. It is, it is as if there is no agreement kan kalau if it is null and void. For the sake of law maksudnya demi hukum ya. So it's just gone, yeah, because it's a mix. The debt and the receivable are mixed. Now by release, this one is easier, yeah, because tentang pembebasan utang, ya, 1438 until 1443. So I just release you from your debt obligation. Yeah, that is the easy way to say it. I just release you. When I release you, then your obligation to pay is terminated. Yeah. If the creditor expressly declares that he does not require any performance from the debtor and release his rights to get payment or fulfillment of the agreement, then the loan relationship is removed. Yeah. Expressly declares. The release of receivable debt cannot be presumed but must be proven. Ya. Tidak dapat dipersangkakan, tapi harus dibuktikan. So you cannot just, I thought you release me from my debt obligation to no. It cannot be like that. It has to be very clear that yes, that's okay. You don't need to pay me anymore. Or yes, that's okay. I consider this as my donation to you, for example. Yeah, so there has to be indication that you are explicitly released. The voluntary return of okay. So even though there is a security held by the creditor, and then the creditor gives it back to you, it does not mean that the debt is released or the debt is removed. Yeah, so that's why this is important, right? If we represent our clients, that there is a release of debt, of course it must be in writing, so it is very clear from the beginning. We of course cannot accept just by accepting the return of something or the return of pledge item. We don't consider it yet as the release from the debt. The release needs to be received well first by the debtor, then it can be said that the loan obligation has been removed because of the release. Because there is also the possibility of a debtor does not like to be released. Ya, itu betul sih. So if you look 1441, what I just explained before, pengembalian barang yang diberikan dalam gadai tidaklah cukup dijadikan persangkaan tentang pembebasan utangnya. So that's why, gadai is only a security, right? It's only an accessory agreement. So by returning the gadai or the pledge, you can see that the creditor deems that the accessory agreement or the pledge agreement is void or is terminated. Yeah, but legally speaking, even though the accessory agreement is terminated, the underlying agreement, the main agreement is still valid, right? So that's why the main agreement, which is a loan relationship, and if it is still valid, then of course there is still no debt release. Now the 7 points related to what we discussed last week about the risk, right? By the destruction of the object that were owned. So this is 1444 and 1445. See? It's very short. Yeah. If a particular item that is the object of the agreement is destroyed, cannot be traded or lost, so it is no longer known whether the item still exists, then the obligation is terminated. Of course, it is on condition that the item is destroyed or lost beyond the fault of the debtor and before he neglects to hand it over. If the debtor neglects to hand over the goods, he will be released from the obligation if he can prove that the destruction of the goods is caused by an event beyond his control. And the goods will also experience the same circumstances even though it is in the hands of the creditor. If the debtor in the event of the above has been released from his obligation to his creditor, then he is obliged to submit to the creditor all rights that he may be able to do to third parties as owners of goods that have been destructed or lost. Okay, I will read the Indonesian ya. So the main thing is jika barang tertentu yang menjadi bahan perjanjian musnah, tak lagi dapat diperdagangkan. So it doesn't have to be destroyed ya, but cannot be traded only. Or loss, ya hilang kan artinya dicuri ya. Sedemikian hingga sama sekali tak diketahui apakah barang itu masih ada, maka hapuslah perikatannya. Nah, hapuslah perikatannya kan termination of obligation. Asal barang itu musnah atau hilang di luar salahnya si berutang. Ya mungkin dicuri, dirampok ya, artinya bukan kesalahan dia tuh. Atau gempa bumi, kebakaran ya. Dan sebelum ia lalai menyerahkannya. Jadi memang kewajiban dia untuk menyerahkan tuh belum. Lain kalau misalnya dia sudah jatuh tempo kewajiban untuk menyerahkan, dia nggak serahkan, lalu dia alasannya musnah, itu nggak bisa. Itu tetap adalah kewajiban dia, tidak hapus tuh perikatan. Tapi kalau dia memang belum jatuh tempo wajib menyerahkan, terus musnah atau hilang, nah itu hapus perikatannya. Sepanjang dia bisa buktikan bahwa itu bukan kesengajaan kan. Si berutang diwajibkan membuktikan kejadian yang tak terduga yang dimajukan itu. Ya. Dia wajib membuktikan. Dengan cara bagaimanapun suatu barang yang telah dicuri, musnah atau hilang. Hilangnya barang ini tidak sekali-kali membebaskan orang yang mencuri barang dari kewajibannya untuk mengganti harganya. Ya, this is like of course you are doing a thief, for example, yeah, you are stealing something. That is a criminal offense, right? So you can be imprisoned because of stealing. But of course, maybe after you stole my things, you sell it out and then the things are gone, yeah. So by suffering the stealing from you, of course I suffer losses, right? Maybe you steal my car, it values 1 billion rupiah, for example. So of course I still can claim against you. Yeah, this is the essence of the 1444, the last paragraph, right? It doesn't release your obligation to repay the value of the money that you have stolen from me. Yeah. So that's why every legal action has a criminal effects or criminal consequence and also civil consequence. Yeah. Not all the time, but sometimes ya. Jika barang yang terutang di luar salahnya si berutang musnah, tak lagi dapat diperdagangkan atau hilang, maka si berutang jika ia mempunyai hak-hak atau tuntutan ganti rugi mengenai barang tersebut, diwajibkan memberikan hak dan tuntutan tersebut kepada orang yang mengutangkan kepadanya. So if he can claim ya, di luar salahnya si berutang lagi dapat dibayar, maka si berutang jika ia punya hak mengenai barang tersebut juga ya. If he can claim it to the third party ya. If maybe he buys it from the third party, from the other seller, and then he has the right to claim when it is gone and everything. So this right to claim should be transferred to the creditor that has to receive that good. Okay, let us continue now. Null or nullification ya, tentang kebatalan dan pembatalan perikatan-perikatan. We discussed this several times also when we discuss about consensual principle, freedom of contract principle, subjective requirements of validity of agreement, objective requirements of the validity of agreement, but this is mainly related to the subjective requirements, yeah. So this relates to the agreement made by incompetent, ketidakcakapan ya, by minors. In here you can see under guardianship ya, di bawah perwalian, or because of a mistake, khilaf ya, paksaan, extortion, duress ya, penyalahgunaan keadaan, improper threat ya, or we call it duress, and also fraud, penipuan ya. I think we have discussed this several times already, even though it is not very detailed, but the concept is the same. When you violate the subjective requirements of the agreement, meaning the first one is the consent, right? The agreement between the parties or the consents between the parties. This is related to the offer and acceptance mechanism that we have discussed also. And the second is the capacity to enter into the agreement, right? So the consent can be violated by mistake, for example, by duress, by threat, by fraud, and everything. So if we understood before, of course, we will not sign that agreement. Yeah. If we realize that we were wrong, we of course will not sign that agreement. Yeah. We will not have signed that agreement. So the nullification, yeah, all obligations made by minor or individual under guardianship are void by law. This is the void by law must be interpreted as can be voided or can be terminated. Obligations made by married women and by minors who are acknowledged as competent are not void by law insofar as such obligations do not exceed their competence. If an agreement is null and void, then no legal obligation is born because of it, and the goods of something that does not exist certainly cannot be removed. Yeah. If it is null and void, then it is null and void, right? It was as if no agreement whatsoever. Requesting the nullification of an agreement that does not fulfill the subjective requirements can be done in two ways. Actively demanding, meaning you file a claim through a court, yeah, or defensively, you wait. You just don't perform it, yeah, when you realize that the agreement is violating the subjective requirements. You just don't perform it. Yeah, you just don't perform it, and then you wait because you will be considered as breaching the contract. You will be claimed, and then when you are claimed, you will defend yourself by saying that this agreement I cannot perform because it was violating the subjective requirements of the validity of contracts. For active claim, the law has statute of limitation, which is 5 years. So, but the 5 years is different, yeah. You have to look into the 1454. I think we discussed this before, yeah. 1454. So the 5 years is a rule of thumb. Ya, dalam semua hal di mana suatu tuntutan untuk pernyataan batalnya suatu perikatan tidak dibatasi dengan suatu ketentuan undang-undang khusus hingga suatu waktu yang lebih pendek, waktu itu adalah 5 tahun. So the rule of thumb is 5 years. So this is different than the daluarsa, because the daluarsa is 30 years. Yeah, we will discuss that after this. But this is 5 years. Yeah. But waktu tersebut mulai berlaku dalam hal belum dewasa sejak hari kedewasaan. Dalam halnya pengampuan sejak hari pencabutan pengampuan. Dalam halnya paksaan sejak hari paksaan itu berhenti. So after the paksaan berhenti, you have 5 years to file a claim to terminate that agreement. Dalam halnya kekilafan atau penipuan sejak hari diketahuinya kekilafan atau penipuan, ya. Because you were having a mistake, right? Or you were defrauded. So you just realize it afterward. So when you realize it, you have 5 years. Yeah, because if you don't do anything within these 5 years, you will be deemed as relinquishing your rights. Yeah, we talked about this also last week, right? About relinquishment of right. You are deemed to have relinquished your right to file a claim. So this statute of limitation is 5 years, is 5 years. When you want to claim, you go ahead within these 5 years. If you don't claim, if you are not claiming within these 5 years, well, you are considered that you are not seeing it as important. The nullification will not be accepted by the judge if it turns out that there is already a good acceptance from the disadvantaged party. Because a person who has received either a deficiency or an act that is detrimental to him can be considered to have waived his right. Nah, you can see in 1456. Tuntutan untuk pernyataan batal gugur. Jika orang belum dewasa, orang yang ditaruh di bawah pengampuan, perempuan yang bersuami, yang bertindak tanpa bantuan suami, atau orang yang dapat memajukan adanya paksaan, kekilafan, atau penipuan, secara tegas atau secara diam-diam telah menguatkan perikatannya, ya, has affirmed the obligation. Setelah ia menjadi dewasa, setelah penghapusan pengampuan, setelah pembubaran perkawinan, setelah paksaan berhenti, atau setelah diketahui tentang adanya kekilafan atau penipuan. So, even though you are mistaken, yeah, you are defrauded, then if you are seemed to explicitly affirm or implicitly affirm, yeah, or explicitly or implicitly affirm that it is okay for you, yeah, maybe let's say like maybe you buy something, yeah, you know that this is not a good thing. It is not a proper thing that you would like to buy actually, and you know that the seller is frauding you, menipu, yeah. But then the value of money is not worth it. Maybe it's only 20,000, for example, yeah. The value of the thing that you bought which is a fraud is 20,000 rupiah. So you just buy it and then forget it, yeah, maybe. So that happens, right? So you don't need to cancel. You don't need to cancel. You don't need to do anything because, okay, you just consider that this is a bad experience. Maybe you just review it badly, the seller, but you will forget it, yeah, because yeah, this is the kind of thing the law considers, yeah, because it happens in our life, you know, penipuan di mana-mana, minta pulsa lah 5.000, 10.000, atau minta ditransfer buat Gojek lah, buat Gokar atau buat apapun lah. Nah itu kan can happen, ya, and it's a fraud, ya, sometimes, or it's just a similar to it lah, ya. So you don't need to claim, you just let it go, and that's it. Okay, the other thing is the implementation of a void condition. Ya. So this is different, ya. Pembatalan and syarat batal. Syarat batal refers to 1265 actually, and 1266. And 1267 actually also, yeah, but the main clause referred is 1265, yeah. Conditional agreement, and 1265 relates to the conditional agreement, perikatan bersyarat, conditional obligation. Conditional obligation is an obligation that depends on an event that is still to come and still will not necessarily occur, either by suspending the rise of the obligation until the occurrence of that event, or by canceling the obligation according to the occurrence or absence of the event. In the first case, an obligation is risen or is born only when the intended event occurs. In the second case, an obligation that has been risen will actually end or be canceled if the event in question occurs. The last kind of obligation is called an obligation with a void condition. syarat batal. So the obligation is canceled when the condition occurs. Now the cancellation is going backwards. It's like a null and void principle. A void condition is a condition which, if fulfilled, will cause the obligation to become void and restitute the parties as though the obligation has never existed. So this is the null and void concept, right? So that is the void condition, syarat batal. When it occurs, then everything goes back to square one. This condition does not delay the fulfillment of the obligation. It only obliges the creditor to return what he receives if such event occurs. So in a sale and purchase, when the syarat batal occurs, the seller will have to refund the money, the buyer will have to return the thing bought. Yeah. In contract law, a void condition is permanently retroactive until the time of the birth of the agreement. Void condition is condition that, when fulfilled, terminate the agreement and bring everything back to its original state as if there had never been an agreement. Yeah, 1265, 1266. But of course, we don't really do this. Yeah. Not every agreement can be just null and void. Yeah. Rental agreement, how labor agreement, employment agreement, how do you return the comfort that you have enjoyed during the lease period? Employment agreement, how can you return the services from your employee that you have enjoyed as boss, for example? Yeah. It's not every agreement can be considered as null and void, of course. Yeah. Loan agreement, let's say loan agreement, if it is considered as null and void, then the debtor will have to refund the money, right? How can it be? Yeah. I don't think it is easy. Yeah. Legally speaking, we will say that because this is null and void, so it has to be back to square one. But how can you really do that? Yeah, refund all the money where where the money is already spent for. So you know the case of AM9 Limited, I think. Yeah, the lender and the debtor giving the money to the debtor in Indonesia. Everything is using English language, and then the debtor cannot pay the money back to the creditor. The debtor is Indonesian, yeah, and the creditor is foreigner, and then this Indonesian files a claim to the creditor, saying that the loan agreement is null and void because it is made in English. It is made in English, yeah, and the court agrees to it, yeah, until the Supreme Court. AM9 Limited, I think, if I'm not mistaken. So it is just considered as null and void. Well, the question is whether or not the debtor is really actually refunding the money, yeah, while in fact it is defaulting its payment obligation. Yeah. So it's not really making any sense. Yeah. And this is, of course, just a legal strategy by the debtor to avoid its obligation under the law. Yeah, well, it's a really bad thing to do. Yeah, even though legally speaking it's possible, but I don't think it's appropriate to be done. All right, the last point, by lapse of time. Yeah, so if you look in 1381 again, yeah, back to the 1381, perikatan-perikatan hapus karena berlaku suatu syarat batal yang diatur dalam bab ke-1 buku ini. Yeah, so that is the 1265, 1266, ya. Yang that we talk about, ya. That's the first book. And then karena lewatnya waktu, hal mana akan diatur dalam suatu bab tersendiri. This is the 4th chapter actually, ya. Pembuktian dan daluarsa. Tentang pembuktian dan daluarsa. the chapter 4 now. So that's why it's jumping until 1946. Yeah. 1946 tentang daluarsa. So the daluarsa is quite long, eh? Yeah, it is quite long actually. It's covering almost many things. By lapse of time is a legal means of obtaining something or a reason to be released from an obligation by the passage of a certain time and with the fulfillment of the conditions specified in the law. The lapse of time to acquire the right of ownership to goods is called acquisitive. Yeah. So acquisitive verjaring, yeah, they call it. Acquisitive verjaring. So you can claim that this is your right after a certain period of time. Yeah. That is called as acquisitive verjaring. That is a Dutch law concept actually. And it is also adopted by Indonesia since 1997 for the land law. Yeah, it is adopted. So it is not originally customary law or adat law, but then it is adopted in 1997 that one can claim ownership of land after the lapse of a certain period of time. And it is actually 20 years, yeah, 20 years. But in practice, it might be considered even shorter time, yeah, to be considered as the owner. But I think the rule of thumb is still 20 years. Or extinctive, yeah. While a lapse of time to be released from an agreement is called extinctive. So you have the right, like what we said before, is 5 years, right? About the nullification, when you are when you were realized that you were mistaken in signing the agreement, you have the right to file a claim within 5 years, right? That is your right, yeah. After that, it is extinctive. Your right is extinctive, yeah, because you are considered as releasing your right, yeah. So that's why you don't have the right to claim anymore. So this is the expiry, the lapse of time, the daluarsa. You can claim something because of the time, or you can even lose something because of the time. Yeah. So we can see in here, so the Indonesian is daluarsa adalah suatu alat untuk memperoleh sesuatu, ya, to get something. This is the acquisitive verjaring. Atau untuk dibebaskan dari suatu perikatan. Ya, you don't have to do anything. Dengan lewatnya suatu waktu tertentu dan atas syarat-syarat yang ditentukan oleh undang-undang. Now, 1967. Now, this is important. All legal claims, either business as well as individual, is expired after 30 years. And the individual who invokes the expiration is not be required to submit any title, and an individual cannot object to this expiration if such is based upon bad faith. Segala tuntutan hukum, baik yang bersifat perbendaan, nah ini maksudnya either property by nature, ya. Perbendaan itu maksudnya berkaitan dengan hak kebendaan, ya. So it relates to the ownership, yeah. If you have land, for example, you have the right to defend yourself, yeah, to everyone. Even though you don't have any agreement with the others, you have the right to defend yourself against everyone. That's the hak kebendaan, kan? Hak kebendaan ada yang mutlak, ada yang relatif, ya. Hak kebendaan itu ada yang terbatas sama yang tidak terbatas. Nah, kalau hak kebendaan itu hak mutlak sebetulnya, karena dia intinya ya bisa dipertahankan terhadap semua orang. Lain kalau hak perorangan, that is based on the agreement. So it is relative against the party who is signing the agreement with me. Hapus, jadi segala tuntutan hukum baik yang bersifat perbendaan maupun yang bersifat perorangan hapus karena daluarsa dengan lewatnya waktu 30 tahun. Sedangkan siapa yang menunjukkan akan adanya daluarsa itu tidak usah mempertunjukkan suatu atas hak, maybe alas hak ya. Lagi pula tak dapatlah dimajukan terhadapnya suatu tangkisan yang didasarkan kepada iktikadnya yang buruk. With the lapse of that time, it removes every legal obligation and leave a free obligation. This means can be paid. That obligation can be done, but cannot be prosecuted in front of the judges. Where if you have an obligation and it's lapsed, yeah, then you don't have any obligation anymore, right? So there is no agreement, ya. Tapi ada perikatan alamiah, so you can do it if you want. If you don't want, you don't need to do it, yeah, because you are not bound to it, yeah. This is not a agreement. This is not a binding agreement. But maybe, yeah, this is like an ethical conduct or ethical respect. Out of respect, you will do it anyway, yeah. But you are not legally obliged anymore. The debtor, if charged his debt or suit in front of the court, can file an exception about the lapse of time of receivables and thus avoid of any claims.